Good morning. This is the January 16, 2025 meeting of the Nevada Commission on Ethics. I would ask Executive Assistant Pedroza to please call the roll.
Sure thing. This is Executive Assistant Pedroza, Chair Shear,
Here.
Vice Chair Wallen. Here. Commissioners Cage and Langton are excused. Commissioner Lowry.
Here.
Commissioner Moran.
Yes.
Commissioner Reynolds.
Here.
Commissioner Smith.
Here.
Executive Director Armstrong.
Here.
Commission Counsel Bassett. Here. Outreach and Education Officer Harvey. I see them online, so. Senior Legal Researcher Hazlett.
Okay.
Investigator Terry.
Here.
And I'm Executive Assistant Pedroza. I'm here. We also have Senior Deputy Attorney General St. Jules.
Thank you very much. I'd like to invite you to join me in the Pledge of Allegiance. Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. I'll take a point of privilege in the public comment section and welcome Commissioner Smith to her first public meeting formally. So welcome. We're glad to have you on board.
Thank you very much. It's a privilege to be here.
Thank you. And so let's open it up for public comment. Do we have anyone here in the hearing room who'd like to make public comment today? Let's step forward to the table here.
Might be easier for me to stand.
That's fine.
My name is Margaret Piskovich. I was the president of the state bar. I was the first female president. I am the one that put ethics into place, believe it or not, 100 years ago in the 90s. The very first complaint that was ever against Mr. Reese was filed by me with the state bar. I have a copy of it, and I sent it out on April 9th. This is in, I don't have my glasses with me, I'm sorry. And this is about, it's gotta be on here, 2023. And I sent everything with it. And in this particular, this was his first one. And I know that his law partner was on the Board of Governors, so I don't think it went anywhere because I never received anything back from the state bar, which I thought at least as a president I would have. In this particular situation, it was, he couldn't tell a conflict of interest from himself. And it dealt with his conflict of interest. And then what he did at the end, he said, well, I did check with the city attorney and the city manager, both of whom are and were attorneys. And he said that they told him it was okay to do. Well, I don't believe that that happened. So in my complaint, I said, if in fact that was true, then those two gentlemen, they can't do anything against a counselor, but I mean, a council member, but if they were asked to, they could be investigated by the state bar. To my knowledge, that never happened. And so in my opinion, he slid through the first one. And I know they just slapped his hands. I know what the result was. But the problem is he's still having conflicts of interest. And I do now follow the city of Reno a little better than other people. I've been on the charter committee. I've done other things with the city of Reno. In fact, I'm going against them in a week. I have a copy of this if anybody's interested, but this is his first one. And like I said, it never went through the state bar. And I'm still convinced that it was because of his association with his law partner on the Board of Governors. But to this day, I don't think he's figured out a conflict of interest. Thank you.
Thank you. Any questions? Thank you so much. Anyone else who'd like to make public comments? Anyone online who would like to make public comment?
We do have members of the public on Zoom. However, none have indicated they would like to make public comment at this time.
Have you received any public comment by email?
We have not received, this is Executive Director Armstrong, we have not received any public comment by email for this meeting.
Thank you. That brings us then to item number 3, close the public comment section of our meeting. Item number 3 is approval of minutes of the November 13th, 2024 commission meeting. We're all provided with a copy of the minutes in our materials. Does anyone have any questions on the minutes?
I don't have any questions. Commissioner Lowry was excused at the last meeting, so she cannot participate on this vote. And Commissioner Smith is brand new, so she as well cannot participate on this item.
Thank you. Appreciate that. Any other questions or comments? With that, do we have a motion to approve the minutes?
Yes, Mr. Chairman, I can make a motion to approve the minutes.
Commissioner Moran moves to approve the minutes.
I'll second.
Commissioner Reynolds seconds. All in favor?
Aye.
Any opposed? Minutes are approved. Brings us to item number 4, discussion and possible action following the received notice of alleged failure to comply in relation to the deferral agreement. Execute an ethics complaint case number 24104C regarding Devin Reese, member, City Council, City of Reno, State of Nevada. Let's start. Do we have any disclosures on this item?
Yes, Mr.
I have
Chairman.
a disclosure, actually.
Let's go with Commission Counsel Bassett first.
Although Senior Deputy Attorney General St. Jules is the acting commission counsel on this matter, I would like to make a disclosure out of an abundance of caution and for transparency. In my private capacity, I am a client of Moffitt, Cox and LaGoy. There's previously been a split of opinion by the commission as to whether a typical attorney-client relationship creates a commitment in a private capacity by a public officer or an employee to a law firm under NRS 281A.065, but I am erring on the side of caution in making this disclosure because I am aware that Mr. Reese is also a client of Moffitt, Cox and LaGoy, although he is not represented by the law firm in this matter before the commission today. My representation by Moffitt, Cox and LaGoy in my private capacity is unrelated to Mr. Reese or any matters before the commission. I am financially responsible for the payment of Moffitt, Cox and LaGoy's fees at the prevailing rate, and I have no other business relationship with the law firm beyond being an estate planning client. I do not vote on or make any decisions on matters regarding before the commission concerning Mr. Reese. However, my representation by Moffitt, Cox and LaGoy in my private capacity regarding matters unrelated to Mr. Reese or any commission matters would not materially affect the independence of judgment of a reasonable person in my position on matters concerning Mr. Reese.
Thank you. Commissioner Moran?
Yes, thank you, Mr. Chairman. I'm a partner with the law firm of Hutchison and Steffen. Mr. Reese was a partner with same law firm during the time of the events alleged in this matter, and his position with the law firm during that time as a part of the ethics law violations alleged here. However, I joined the firm after Mr. Reese had already departed. It's my understanding that Mr. Reese's last period of employment was in February of 2024. I came on board a month or so thereafter. We did not have any overlap at the firm, and I do not have any personal relationship with Mr. Reese, not in his capacity as a city councilman for Reno, but also as a colleague and partner to him with the firm. I also was not involved in any of the events alleged in this matter and do not have independent knowledge of the events alleged outside of these proceedings before the commission. Given Nevada's public policy in favor of public officers performing their duties and voting on matters, and that a reasonable person in my position's judgment would not be materially affected by these circumstances, I will not be abstaining on this matter. I will be voting. Thank you, Mr. Chairman. And I'm taking advice of counsel on this as well.
Thank you, Commissioner Moran. Commissioner Lowry served on the review panel for this matter, and therefore she will not participate in the consideration of the matter. Also, Commission Counsel Bassett served as associate counsel in some of the earlier proceedings, and therefore she will not participate. And Senior Deputy Attorney General Lena St. Jules will act as commission counsel for this particular matter. We have the parties go ahead and, or the council go ahead and identify themselves.
Thank you, Chairman Chair. Yeah, I'm Jonathan Shipman. I'm here on behalf of Mr. Reese in this matter. And Ross Armstrong here representing myself as Executive Director.
And it's my understanding that the parties have discussed some potential demonstrative exhibits and have agreed that both may be admitted.
Correct.
With no objection, then we'll go ahead and have those made part of our record. So. So we're considering today an alleged failure to comply with the terms and conditions of a deferral agreement entered in ethics case number 22-104C. An action to be taken if the commission finds there was such failure to comply. For presentation purposes, we'll first hear from Mr. Armstrong. And then we'll hear from Mr. Shipman. And my understanding is, again, the parties have agreed that Mr. Armstrong will then have a brief rebuttal. So Mr. Armstrong, please go ahead.
Thank you, and Ms. Pedrosa, if you can place my demonstrative aid up. This is, in my mind, a simple and straightforward matter. Within a handful of weeks after Mr. Reese agreed with this commission by way of a deferral agreement to maintain compliance with the ethics law, he engaged in a course of conduct contrary to the ethics law. In the review panel in case 22-104C, the case before us, that review panel determined that facts established credible evidence that just and sufficient cause existed to refer that matter to the commission, but that a deferral agreement was appropriate. Reese agreed in that deferral agreement, and there were 4 different requirements of that deferral agreement: that he complete training, that he produce a conflict of interest check process, that he submit disclosures when items involving his firm came before the commission, and that also he maintain, and I think the most important requirement of all our deferral agreements is that once you're on a deferral agreement, you need to continue to obey the ethics law. That is the part of the deferral agreement that Mr. Reese failed to comply with. The elements of a violation of this part of the deferral agreement is that it has to be another ethics complaint. We received 2 ethics complaints regarding Mr. Reese. The conduct in that complaint needed to happen after the deferral agreement was entered into. The complaints include behavior both before and after. So because there is conduct after, it constitutes a violation. And that a review panel determined that just and sufficient cause exists to proceed with that new complaint. This protects individuals who enter into a deferral agreement from anybody just filing a complaint and triggering an end of a deferral agreement. It says, look, if there's a new complaint, there should be an investigation that should be presented to a panel along with that person's defense of themselves, their opportunity to respond. If at that point a panel says this new case has enough evidence to proceed, that's what triggers the violation in this term of the deferral agreement. And that is what occurred in this case. In reading all the materials, there's not really a dispute that a review panel has made that determination that that complaint included conduct after we enter the deferral agreement. A deferral agreement really is sort of a gift from the review panel that says, look, there's evidence here that you may have violated the ethics law enough to send this to the commission. But we think with the right resources and guidance and monitoring, we think it's possible you may be able to comply with the ethics law. The carrot in a deferral agreement is if you comply, at the end, the case is dismissed. The stick is if you don't comply, then the case will proceed the way the review panel has determined it should. So what exactly happened in this particular case? If you take a look at the timeline in your materials, we have the second case involves travel. The first case involved disclosure and abstention, and the second case involves travel. Essentially, Councilman Reese using city resources to fund his own private travel interests. If we zoom in on the time period that is after the deferral agreement, the time period that is relevant for you today, you can see that Reese entered the deferral agreement in April 2023. That in May of 2023, he completed ethics training. He emailed that he had completed that ethics training. Shortly after then there are 2 different trips. The total of the private benefit of those trips, as indicated in the response and in the investigation, is in excess of $1,300. Then it takes a while for there to be discovery of that behavior that violated the ethics law. And in March and April of 2024, complaints were filed. We then conducted our investigation into these new complaints. And in September of 2024, the review panel made its determination that just and sufficient cause existed to proceed. That is 16 months into the deferral agreement. I note that the first trip that violated the ethics law was just 3 months, 90 days into the deferral agreement. The second trip was just 5 months into the deferral agreement. When you look at the moment that triggers the, what I would argue, the cause for to vacating the deferral agreement, we still had a third of the deferral agreement left. We're closer to the end of the deferral agreement now. The parties did try to engage in global resolution. That did not occur. There has to be time for Mr. Reese's counsel to respond to the notice. But that's, like 66% of the way through the deferral agreement is when the review panel said, yes, this conduct that occurred just months into the deferral agreement, that there's just insufficient cause that Mr. Reese's conduct was not in compliance with the ethics law. The response argues that in the interest of justice, the commission should just essentially forgive and not do anything in response to this violation of the deferral agreement. And I can't disagree more. I think of the requirements of the deferral agreement in Mr. Reese's case, the requirements of training, of setting up these checks are designed to be a help to Mr. Reese, to help him figure out the ethics law so that he can bring his conduct into compliance. Again, the most important one is that we're providing you this help, we're providing monitoring, you need to comply with the ethics law in all parts of your conduct. Again, the conduct that violated the ethics law is just weeks after he completed the deferral agreement. It's after he took training, which includes content about not using public resources for private gain. The response also, indicates that if the commission proceeds, there's not going to be much of a difference in what occurs, which I think is a lot of speculation, but so that the commission is aware, right? If the deferral agreement, if the commission decides that there's been a violation of the deferral agreement, which appears both sides agree, there's no really contesting that a review panel has made a determination as required that meets the deferral agreement requirement. If you don't do anything in response to that violation and the deferral agreement period ends, then Mr. Reese will have no violation in that previous case. If instead you do what I'm asking and vacate that and refer it for further proceedings before this commission, then you'll have an opportunity at that point to let the facts lead you to whether there's a violation. I think it's clear, obviously, that there are. I wouldn't be here asking you to do this today. And there's lots of speculation about whether the violation will be willful or non-willful. Again, that is simply speculation. I think there are facts, there are mitigating facts in this case that may lead to a non-willful violation. There are others, aggravating facts, I think, that might lead to a willful violation. Either way, a full proceeding where this commission can determine if there's a violation would result in a violation. A violation is very different than no violation at all, which is what they're asking you to proceed with. So I'm asking you to reject the arguments and the response and to declare loudly today that you can't be on a deferral agreement and violate the ethics law and have nothing occur as a result. Thank you.
Any questions for Executive Director Armstrong? Go ahead and move them to Mr. Shipman.
Mr. Chair. Demonstrate the aid.
We've all got it in front of us.
Great. That's better. Just would like to make a few points here. Number one, full disclosure on. I am not representing, the city attorney's office is not representing Mr. Reese on the other two cases that are in front of the commission. So I just want to make that clear on the record that there isn't confusion that we're presenting both in all of those efforts. So that's one point. Another point is I really want to call out the difference between the case in front of you today, 22104C, and the other cases that are pending. The first case, the case that we're talking about today, we have to understand, it was a disclosure and abstention alleged violation, right? NRS 281A 420. And again, the allegation essentially for just the public is he voted to approve or a collective bargaining agreement at a city council meeting, and there was allegations that that violated NRS 281A 420. That is a different type of ethics violation, I would argue, than what the allegations are in 24036C and in 050C. Both of those involve, again, as the executive director talked about, allegations that Mr. Reese used funds, city funds, to pay for personal expenses. Again, one is about disclosure and abstention on the record in a public meeting and voting. On the ones that are pending that you're going to be hearing about today involve the use of government resources. So first I want to just make the point that just in terms of the type and the nature of the arguments or the types of the alleged violations, I would argue they're not comparable. And quite frankly, to the executive director's point, yes, Mr. Reese did take ethics training. Yes, Mr. Reese did set up a conflicts checking system. Yes, Mr. Reese did regularly submit his minutes to the city, to the executive director in cases where HNS clients did appear. But again, none of that type of corrective action, which is, I think, I would differ on the assertion that deferral agreement is a gift, is not a gift. I would differ on that point. And a deferral agreement is a form of potentially progressive discipline. It's designed and it's put in place, I think, by the legislature to really be a device to say, well, there's something potentially here, and we want to give the party a chance, and we want to correct that conduct. And I would submit that on the 420 violations, we see that. All right, we're not seeing a pattern in practice of violation of NRS 281-420. Mr. Reese has in fact complied with all the conditions except for the one paragraph that, again, the executive director characterized as the most important provision. And I would somewhat disagree with that too, because I do understand that that provision does, and my reading of it, it has a deterrent effect and a deterrent value. And that's the point of putting that in there, is to put the accused on notice that, hey, people are watching. You need to look at your activity. You need to think twice before you do this. This is a way to say, you know, we've got you on the hook. Now, that's what the agreement says, but I think the law says a little bit different. And that gets to the point that, you know, the deferral agreement is still on his record, right? So, and under NRS 281A 7751B, that can be used in subsequent proceedings in determining, you know, whether or not violations are willful or not. So to say that A, it's a gift, and B, that it's needed for this other, we need to process this and go to full adjudication of this, because we need this in the other case, which again, I want to point out there that where we are in that case, yes, there is no disagreement over the review panel having that case going forward to the next step. But again, the substance of those allegations have not been proven definitively yet, and this body has not ruled on that. And so I would submit that in a certain sense, we're putting the cart before the horse. That this, to the extent that this needs to even be you need to come back and look at it, or the commission needs to come back and look at it. I think, quite frankly, that I would submit that you know, the other two cases that are currently pending need to be adjudicated, right? Because that right now we're just operating, and the commission is operating on allegations. This would be the point. And again, I think that underscores the point that you don't need, you don't need to adjudicate what's before you today to even use those allegations. The law allows you to do that currently. So I'm left with what's the point of going and adjudicating this case further? If we get to the end of it, he's completed the ethics training. They've developed and implemented a 281 conflicts checking system. And again, and there's no dispute about this, he's been in contact over time with the ethics executive director on making sure that that pattern of behavior was in fact corrected to the extent that there were problems. So I would argue that the deferral agreement is not a gift. It worked. It worked. And for that reason, you don't need to go back and revisit it. And to the extent that you do go back and revisit it, my question is, what is going to be the outcome? Because I would argue that you're going to have to look at that violation potentially in another form at the time that it was committed, right? And that was a first-time violation, arguably. And that was, again, the nature of that violation was a disclosure and abstention. Okay, so it's not, of the type and the nature and the kind of that you see in the other two cases. So I appreciate, the executive director's comment that, that this is important. And I can understand it being used to say, well, is he an ethical or unethical person? I get that. And if that's the argument in these other two cases, I get that. But I'm saying you don't even need that. You don't even need to fully adjudicate this deferral agreement to do that because that's already allowed for under the law. And again, I would keep coming back to the 281A 770. So whatever, regardless of whatever comes out of this, be it the panel, be it the commission, the concept is that, and the law requires that you treat comparable situations in a comparable manner and ensure that the disposition of the matter bears a reasonable relationship to the severity of the violation or alleged violation. Again, we're not here to determine if in a broad sense, Mr. Reese is an ethical or unethical person. At most, what we're looking at is on the date that the conduct occurred in 22104C. What happened and what would be the appropriate response to that? And again, I would argue that the appropriate response was a deferral agreement. The conduct was corrected. There's no facts in the evidence showing otherwise with regard to that issue, disclosure and abstention. And therefore, it's time to close the door on that, which doesn't mean that the commission can't open the door at a later date. Again, to the executive director's point, we're 18 months, 20 months into this agreement at this point in time. This is like, and the other two items were kind of history too. So anyway, that would be, we'd submit on that, and that resubmits that that vacating the deferral agreement and conducting further proceedings in this particular case really doesn't benefit anyone or the commission, and it's not particularly a great use of commission time or resources for the interests of justice. So with that, I would yield.
Questions for Mr. Shipman before we move to rebuttal? I've got a couple.
Yeah, please.
First of all, Executive Director Armstrong says that the training included training on use of government property.
The training was the training that was on the, and I would defer to the executive director on that.
Yeah, I can confirm the training that was required by Mr. Reese was to watch what was our old, about 45-minute long, complete ethics law video, in addition to a special video on understanding commitments and crimes.
So I guess I would ask Mr. Shipman, what's the point of requiring him to take the full training if we're only going to consider whether the violation is a comparable violation?
What was the point of doing the full training? I think best practice, I think that's pretty much the best practice. Anytime that you have a deferral agreement, you give the accused another. I mean, all the deferral agreements I've seen say that, hey, you need to take another look at the ethics law. So I think that that's just a practice. So I'm sorry, the question again was, that's the first
Well,
point.
what's the point if we can only find a violation or only find that the deferral agreement to be vacated if it's comparable? Your argument is this is not a comparable violation.
The allegations in the other cases are not comparable to the violation that is currently in front of you, the alleged violation today. Because under the broad umbrella of ethics law, yes, right? But under specific kind of the nature and the type of the alleged violation, one is like how a public official is conducting him or herself in a public forum relative to somebody potentially has a commitment in a private capacity to, and the procedural requirements that you need to disclose and abstain. The other is you stole money. I mean, those are like, I mean, and I would argue, I would say that, like, at least in my time as a city attorney, I mean, the whole abstention, disclosure abstention component, I mean, there are, as this commission has recognized, there are issues that are maybe not clear as day at times, right? And that require the help of, counsel to figure out what they have to do and what people have to do under that sort of disclosure and abstention requirements of 420. Don't really need a lot of that with maybe some of the other. Counsel doesn't have to give you a lot of advice and guidance on, is it ethical to steal, right? I really think there's a much different kind of in nature of violations that we're talking about here. And again, none of it has been proven. And I do not begrudge, or I'm not standing here saying the commission doesn't have the right to go and prove it or not. And in fact, on those other ones, I would say, don't prove it. I mean, if that's where it gets to. But I would say that until that is done, what you're looking at are allegations in the deferral agreement, because that hasn't been proven out either. But you need to actually do that, because if you've already gotten the behavior corrected on all of it counts, is this provision really more of serving a deterrent value? And now, whether it did or it didn't work, I mean, is it a good use of resources to continue on down that track? And I'm just asking that because to me, it just seems like you're going to get to the same endpoint on the abstention disclosure rule, and what have you got for it? I mean, those are resources that could be used for other cases and whatnot. So
There's nothing in the deferral agreement that requires the violation to be a disclosure and abstention violation.
the other charges were dismissed. So I think at this point, we're just left with abstention and disclosure. That's how I read it.
In terms of any other violation, so your argument is that it has to be a disclosure and abstention violation to vacate the deferral agreement? And
No, I think the way the deferral, I'm sorry if I'm maybe misunderstanding. The way the deferral, I don't think there's a dispute over, there's an allegation that he violated the ethics law and that triggers this provision. I don't think there's a dispute over that.
Thank you.
It's just that the point being is that there's allegations over here and that have yet to be proven. And even the deferral agreement, I mean, we have stipulated facts, but I mean, that's about as far as it's been proven at this point. So
Other questions from commissioners?
I was gonna wait till we get the rebuttal.
Okay.
Yeah, I'm gonna wait to the rebuttal. Wait.
Okay. Online, no other questions? Let's go ahead with the vote. John Armstrong.
Thank you, Mr. Chair. You hit it, right on the head. There's no requirement in the deferral agreement that it be like hitting the same bingo square twice, right? The language in the deferral agreement says Reese must comply in all material respects with the provisions of the ethics law set forth in NRS chapter 281A. The ethics law does have some language that says, you know, if someone has a subsequent act and they got a previous letter, but the letter was on a totally different subject, maybe that letter doesn't have so much weight. There's none of that type of language in our deferral agreement, part of the statute, right? So if it was just a previous letter of caution or instruction on a totally different topic, you might be able to discount that. I don't think you can discount it just because it's on a different part of the ethics law. I think, you know, for a period of time, I oversaw our youth parole bureau, and you'd have youth, you know, juveniles who had committed a serious offense and they're out on parole, and then a, you know, standard requirement that is follow all laws, and they get like a speeding ticket, right? Well, you don't send them off to a facility again because they got a speeding ticket. The same thing has happened in compliance cases in this one in our office, where somebody maybe is late on turning in their training evidence, or they're late on a payment. We try to work that out, you know, before bringing it to you as a particular violation. In this case, you have an initial ethics case about disclosure abstention. And then I think you do have a, you know, what has been characterized, I think appropriately, the allegations in this new case is that Councilman Reese has stolen money from the city of Reno, from the people of the city of Reno, to fund his own private travel. That is a serious case. That is not like I'm bringing before you, he failed to get his acknowledgement in by January 15th, or some other, you know, minor infraction. This next case, I think, is a very serious matter. And so I think that should weigh on the appropriateness of, if as Mr. Shipman says, that part of the deferral agreement is designed to be a deterrent, it clearly didn't work, because within weeks of promising to this commission through signing that agreement, he would comply with the law, did not. There are two things you have to decide today. One, is there non-compliance with the deferral agreement? There's really not a lot of debate or discussion on there. The requirements in the deferral agreement have been triggered. And the second question is what to do. I'm asking you to vacate it and proceed, you know, with additional proceedings in this case. I would also ask you to think about, you know, deferral agreements officially became part of our process about in like 2017. They're somewhat of a new animal, so I can't point to what we've done in the past, but think about what message you might send to others if you were to not act in this matter. If you were just to say, you know what, it's okay. We don't really care if you violate parts of a deferral agreement. We're just gonna, you know, close out the case. I think that message to other people who find themselves in a deferral agreement would undermine the goals and aims of this commission. I think you have an opportunity to say, you know, when we provide you the opportunity to be on a deferral agreement, we believe in you, but we also are trusting that you will comply with the law. And if you don't, the stick part of that agreement comes into effect. So I'd ask you to find that the deferral agreement has been violated and vacate the agreement and continue on with further proceedings in this matter.
Right, let's, thank you. Let's start with any commissioner questions for either Mr. Shipman or Mr. Armstrong, and then we can move into questions for our council or each other. Commissioners, Commissioner Reynolds?
Yes, Terry Reynolds for the record on, I would agree that case 22-104C is not factually connected to the case about misuse of city funds for travel on that. However, this is actually for both of you, but was there in that regard, was there a conflict waiver discussed on the front end of the collective bargaining? Was that an issue that was discussed by the city attorney's office prior to or during the negotiations?
So did,
Was there a conflict waiver presented or discussed by the union's attorneys at the time or by the city attorney's office prior to those discussions? And we're getting ahead of ourselves a little bit here, but I wanted to know if there was, because that to me is a very relevant issue in terms of going forward with that portion of that case.
Let me see how I can answer this. I mean, as far as, was there a conflict waiver presented by the client for H&S?
Yes, because they would, having members, working for the same firm, they may want to have a conflict waiver on
That I don't have information on that. I'm not privy to the West issue. I don't. This point in time, specific information.
Mr. Armstrong, was there any investigation, discussion of that issue regarding that case?
Yeah, I would, I have to double check the deferral agreement, but I do recall from the investigation that there were certain processes put in place at the law firm to seek to comply with attorney ethical requirements. What there was not is like a system in place to ensure compliance with governmental ethics law.
So in that regard, from my perspective, then I think we should defer and review that matter before closing out the deferral.
Yeah, what I can tell you is in the 104C, the facts that I would seek to prove at a adjudicatory hearing would include that at a closed door meeting, Mr. Reese participated without any disclosure or attention when they were discussing clients of his law firm. And that in a public meeting, he made an incomplete disclosure. I think there'll be probably arguments about whether that was an intentionally misleading disclosure or just not adequate in an open meeting regarding these clients.
So in a sense, you would say that that matter is still not resolved. That issue is not resolved.
Right, if the agreement is, if the deferral agreement is vacated and we proceed at an adjudicatory hearing, we would present those facts and arguments.
Thank you.
Other questions for council?
Mr. Shipman, I'm really struggling with your reasoning why you think that the deferral agreement that says any violation of 281A would be cause for vacating the deferral agreement. And you're saying that because it wasn't a disclosure and abstention issue, that it really wasn't a violation of this deferral agreement, but it was still a violation of the ethics law with the misuse of government property. So I'm really having a hard time understanding that logic that we can have a deferral agreement that says you cannot violate the ethics law, and then something happens and you violate something else in the ethics law, but that's not how the deferral agreement is written. I'm really struggling with that.
Yeah, no, that's a fair question. I think where we differ maybe is kind of how we're coming at the issue. And I think I've characterized what those comments say to me is that you've decided that he has violated the ethics law on these other two cases. That's the point. That's your departure point. That's not my departure point. My departure point is, yes, it may have gone to a panel, but there's still a full adjudication of that hasn't happened. So in my mind, there's a debate about whether there was a violation in these other two cases that are pending in front of you today, or at a later date. And my point is that if you're using, I would characterize that as an allegation of a violation. So there's no dispute over an allegation of a violation that went to a panel. Does that trigger the agreement? Yes, it triggers the agreement, but that's different from the merits. The merits are, we don't know if he's stolen money from the city of Reno. That has yet to be proven out by the executive director. So to say that, if you assume that, then of course, then the reasoning that you're giving me makes total sense. It's like, yeah, these are two bad acts, and it's more of the same. But I'm not conceding that, because I'm saying there's still arguments, as we talked about, that need to be made in 104C. And there's still arguments that need to be made in 56C. And once that's done, then the analysis that you presented, I think, either bears out or it doesn't. And so I'm just saying that if you don't, and you don't need that is the point. You really don't need that in the other case. You don't need this case to make your case in the other case, and you don't need the other case to make your case in this case. I mean, they're going to stand on their own Now, again, it's gonna, at the end of the day, the potential remedy or whatever the sanction is, there may be some interplay there, but you already have that under the law, that you can use one result in one case and another case. I'm just saying neither one have been fully adjudicated. Does that make sense?
So if I can follow up on that, your argument here is that Mr. Reese has not been found to have violated the provisions with regard to misuse of public property. And so there's not an actual violation yet that's been found. Just insufficient cause has been found by the review panel, which is what was required by the agreement. What's to stop, and I understand the city attorney's office will not be representing Mr. Reese in the upcoming pending cases. What's to stop counsel for Mr. Reese from making the same argument that, well, in 104C, I was never found to have actually violated. There was a total agreement, so I wasn't found to have violated that. So you shouldn't give it much weight if you give it any weight at all.
If I understand the question, I mean, I think there's, and we've seen this in another case, in that there will be a motion to use the prior case, and it's deferral agreement. It's written, letters of caution. So it's broader than just the deferral agreement. So I don't think there's a barrier.
Well, I understand it can be used, but I
Yeah.
guess I'm suggesting that counsel for Mr. Reese may argue that, well, you never actually found a violation there. There was a deferral agreement, and that's lesser than an actual finding of a
Well, and
violation.
I think that's a fair argument, and that really goes to this body, right? I mean, it's like, what do you want to ascribe to the weight of that? Do you view deferral agreements fundamentally as a form of corrective and progressive discipline? That, is to get a result, better conduct? Do you view it as a gift? Do you view it as a sanction? I mean, that's really, I think, within the purview of the commission to decide how you want to, measure that. And I'm not here to tell you, there'll be arguments, but I'm pitching you today. This is not, I think these are the types of questions the commission has to wrestle with.
Understood.
So if the deferral agreement is there to promote better behavior going forward, more ethical behavior. And Mr. Reese, he did ethics training. He learned about not using government property, but then he took 2 flights, right? After he had done the ethics training, and he has this deferral agreement in effect. So the agreement's not really working because he continued to commit ethics violations. Maybe it wasn't
Well, and again,
extension and disclosure, but now he committed something else.
again, I'm not here to, I mean, I understand the argument. I think that's maybe putting the cart before the horse in terms of what the facts are. I think you're gonna hear argument and you're gonna hear evidence in the other case. And you're gonna have to get that before maybe you can make that definitive statement today. It would be I'm just submitting that. I get it. But it comes down, I mean, if you come into this with the idea that we've already adjudicated the other 2 cases and he stole money, then of course, we're gonna go down the pike on this other one too, because this is another bad one. But if you come in with it with like, look, we haven't done that. And if we're looking at this conduct here and it's not related to that, I think there's a point being that like, look, it worked. The deferral agreement worked. There is no problems regarding abstention or disclosure. And again, I think the other case is going to fall or stand or fall on its own merits. And do you really want to at the end of the day, do you really want to cloud that case and that adjudication with what's happened to date and what's happening in this case? So, I mean, it's, again, it's a pitch, so.
Executive Director Armstrong, do you have a sense of when the pending cases will come in front of us?
We do not have a scheduling order for the other 2 cases. We had a formal settlement conference just before Christmas, and so the scheduling order would still be pending. The time limit, the 60-day time limit has been waived, so I would imagine sometime in the first half of this year is when we would be ready on those other two cases. They are the more recent cases are factually more complex than this first case in a lot of ways. And so it would kind of depend on to what extent there's stipulated facts in that matter. I think for me, I would note that, you know, we establish what crossing the line is in the deferral agreement. And we don't make it, you violated the deferral agreement if a complaint is filed against you, because anybody can file any sort of wild complaint. We don't even make it, somebody has filed a complaint against you and we've accepted jurisdiction because we think there's enough there to take a look, right? The line that you've established is if there's a complaint filed against you for conduct that occurred after you entered the deferral agreement, and after that is investigated by the commission and the person gets a chance to provide their full response, and all of that information, the investigation and the response goes to a panel, and that panel determines there's just and sufficient cause to proceed, that is what triggers the violation of the deferral agreement. So I don't think it would be wise for the commission to move that line to, you have to be found to have violated, like formally violated new cases in order to vacate the deferral agreement. In most cases, it wouldn't happen before the deferral agreement would be over. But I think the way that it is structured, where that line is to say, this is like, you know, an educational, you know, deferral process where we're trying to get compliance from you. If we get to that point where there's just and sufficient cause that you have not been in compliance, then keeping that deferral agreement hanging out there to ensure compliance is not useful to any of the parties.
Any other questions for council or either Mr. Shipman or Mr. Armstrong?
No questions.
Questions for our council, and we can, if needed, go into
I would like to,
closed session to do that.
I would like to go into closed session.
Yeah, I don't, we go into closed session to deliberate or just to have
Deliberate.
legal discussion? Did you move to do that? Or should you move to go into closed session? Yeah.
I'm right. I'll make a motion that we go into closed session to deliberate and ask questions of council.
We have a second from Commissioner Reynolds. Any discussion on that motion? All in favor?
Aye.
Aye. Go ahead and close the meeting then, and we'll go back on the public record. Executive Assistant Pedroza, has the Zoom channel been opened back up to the public? All public members back and have access?
Yes.
Thank you. We've had an opportunity to discuss with our council. Any members of the commission like to make a motion on this matter? Vice Chair Wallen.
I move that the commission find that Reese has failed to comply with the deferral agreement. I further move that the deferral agreement be vacated and that the commission conduct further proceedings in this matter.
I'll second that motion.
Any,
Mr. Reynolds.
just in terms of deliberation on the motion, I just want to put on the public record that I think the commission discussion found that, yes, there had been a violation of the deferral agreement. That there has to be a consequence if deferral agreements are violated. That the appropriate consequence in this case was to vacate the deferral agreement and let Mr. Reese make his case on both alleged violations. And that the trigger in the deferral agreement is a just and sufficient cause finding by a review panel, not a full finding of violation. And that is a condition that is permitted by NRS 281A. With that, any other commissioners have any comments they'd like to make? Then we'll go ahead and call for the vote. All in favor of the motion made by Vice Chair Wallen? Please say
Aye.
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 Any opposed? It's unanimous. Again, Commissioner Lowry abstained because she served on the original review panel. But unanimous among those voting. Thank you, Mr. Shipman. That will bring us to item number 5. Public comment, discussion, and possible action on the proposed language access plans pursuant to NRS 232.0081. Is there any public comment on this matter? We have something that just came in the chat.
Yeah, I just saw something in the chat.
And for, while we're reviewing that, Mr. Chair, there's no members of the public here present in Reno. And we received no written public comment on this particular item. One of the requirements of NRS 232.0081 is that you allow for public comment on the plan, which is why we have a special public comment period for this agenda item.
We have a member of the public, Laura Fussell, sorry if I'm not saying that right, typed into the chat public comment. According to the meeting materials, page 10 of 22, this commission's outreach and education officer has been supported with funds to enhance ASL skills. I'm interested to know which sources are being used for ASL learning. I'm also curious if there's been any meaningful connection with other existing state resources related to the deaf and hard of hearing community, such as the Commission for Persons Who Are Deaf and Hard of Hearing. And there's a link for the Communication Access Services Program. There's also a link, both currently housed within Aging and Disability Services Division.
Executive Director Armstrong, do you want to address that? I think that's part of your presentation.
Part of the presentation.
Why don't you go ahead with the presentation, and when you get to that section, if you could
Yeah, I
very
will.
specifically address that.
I will, to the extent I can today, and
Yeah.
of course not, I'll follow up. So, NRS 232.0081 requires agencies to have a language access plan. This was initially passed, during the pandemic with a special focus on making sure that people had access to government services, during the pandemic. And so the commission is catching up on this requirement for ourselves. You can see that we established the purpose definitions, and then the plan, we used a template from the Governor's Office of New Americans to develop this plan, so it follows that template. It includes an assessment of our existing needs. We interact, we're not like an agency that provides health or employment or those types of services, but we do interact with the public in terms of education and outreach, receiving advisory, opinion requests and complaints, and in our public meetings and hearings. And so, in doing that, you have to identify the demographics of the person served. We don't currently collect any demographic information as part of our form collection. But we do know the general census information in terms of languages other than English. Spanish is by far and wide the top alternative language spoken, followed by Tagalog and Chinese. The inventory of language services currently provided. All state websites have a Google Translate widget. The Office of New Americans template said, ask your IT folks if they can get you like use, and so you can see what languages people are viewing your site in. But we reached out to IT, they couldn't provide us that information, otherwise I would have put it in the plan. In addition, when we post our meetings on YouTube, there's a way to have closed captions in various different languages on your meeting. So if somebody wants to review a meeting and have closed captions in the language that they're more familiar with, that is available through the YouTube posting of our items. And then we also on all of our agendas say, if you need additional assistance in accessing our meetings, please contact us. Of course, that's in English, and so that's not helpful if English is maybe not your first language. So those are opportunities for improvement in the future. We have currently provided funding and training registration approval for our outreach and education officer to enhance our American Sign Language and Spanish language skills. I would ask Sam if they could tell me like exactly what that is that they've entered into. They had to run to the MSHE meeting, so I will find out what those are and we'll collect the information that Carrie indicated.
Yeah,
But
you could report back to us on that.
I can report back to you on what those particular courses are. And the So that's what we currently do in terms of training. We have not interacted with the services provided, like the public commenter discussed with ADSD, but that's certainly something that we can explore going into the future. And that would be one of the things that we identify in 6 as the areas where the commission can improve our language access services. So one would be to get our vital forms, you know, into the different languages, those top 3 different languages. And then having the translation of the ethics manual, which is not, it's not a vital form and that you don't need the ethics manual to interact with us, but having it in those different languages could help educate folks. And then the ability to request translation services for public meetings, perhaps like on our agendas in different languages so that people know how to go about that process. And then the plan will be reviewed annually, as is, I think, like, you know, every other year is required by the statute, but I think it makes sense for us to review it annually. This is our first plan, so this is a starting point for us as a small agency. We don't have a whole lot of capacity, but this is, you know, an important statutory requirement and important in terms of the commission's aim of making sure we're appropriately providing services to all towns.
Questions for Executive Director Armstrong on the plan?
But to say, Ross, I can give you some assistance on that in terms of, because of the breadth of business and industry and services that we had to offer, in the context we had, I can give you some resources, to contact.
That would be great. I know that there's, you know, there are various ways that you can engage, especially with translation services for live translation, those types of things.
And I note that a number of these things, we currently don't have fiscal resources. Have we asked for resources in the current budget for any of these items?
We have not at this point asked for these additional resources. There was a bill that would have required the vital forms piece. Last session, we did the research and I think we estimated it would be about $3,000 to do the translation. I think that bill required like the top 10 languages. So we can certainly take a look at our operating resources and if maybe there's some additional funds to shift around to get some of those forms translated. You certainly want to make sure you go with a credible translation service and not just like
Yeah.
Google Translate.
Google AI.
So there's not currently a line item in our budget for these types of activities.
But obviously, we're going into a session, so it's not something we've requested in the
Correct.
in the current budget. Okay. Maybe something we should talk about or consider, whether we should make that request. Yeah. Any other questions, comments? Any other public comment on the plan? More in the chat that should be shared and then out for the record? No.
Yeah.
Okay, let's move on then to item number.
I'll make a motion.
Oh, do we need a motion there to approve the
Mhm.
plan?
Yes.
My apologies. Go ahead.
I move to adopt the proposed language access plan as presented and discussed.
I can second that, Mr. Chair.
All right, all in favor?
Aye.
Aye. Any opposed? Motion passes unanimously. Item number 6, delegation of authority to the chair of the Nevada Ethics Commission on Ethics to represent the Nevada Commission on Ethics at the 2025 legislative session or any special sessions called, including without limitation confirmation of authority to direct staff pursuant to NAC 281A155 on matters relating to proposed bills affecting the commission. Executive Director Armstrong.
Thank you, Mr. Chair. The legislative session starts soon. The state of the state was last night. And one of the things that we have done is, you know, rather than have emergency commission meetings, you know, anytime there may be a bill we have an interest in. In the past, we've established a legislative committee, especially when we have our own bill, and we may need to consider people trying to amend our bill. In this particular one, delegates the authority to give me direction on what to do on legislative matters to the chair. There's a Nevada Administrative Code that says if the chair is unavailable to do a duty, that the vice chair may do it. And so this matter simply says that if there's a legislative issue and I need some direction of what might be the will of the commission, I can go to the chair instead of, calling a special meeting. Obviously, throughout the legislative session, we'll have our meetings as normal. In addition, for the commissioners who weren't here during the last legislative session, I've discussed this with the chair and vice chair as well. Once the session starts, I will send out a weekly informational update about the session to everybody. And if any one particular commissioner has questions on any of those items, I can engage with that commissioner at that time. But this one delegates that authority to provide direction to me, to the chair from the full commission.
Questions, comments on the proposal by Executive Director Armstrong? I guess I'll start. This is something I'm willing to do. I would want to, I guess, consult with the vice chair whenever possible so that we know we're in agreement moving forward. So if you're going to try, reach out, if you could try to reach out to both of us. And I think, and again, include any discussions in your weekly report so that the rest of the members are aware of it if it goes forward that way. I think I am in Carson City about 2/3 of my time. I know
Yeah.
Vice Chair Wallen is just outside Carson City, so we are available to assist if necessary. But with that, I'll open it up to any other comments or questions from commissioners.
No, I think the detailed motion, I think it covers that contingency in here, so I'm good with that. I think that's a good plan.
Any other comments, questions?
Yes, Mr. Chair.
Commissioner Moran?
Yes, thank you. No, I think that this item is perfectly suited. I think that you're and the vice chair, with the vice chair's assistance, I think you both are perfectly suited to go forward advancing, whatever interests we have as the commission or as a commission as a whole. So I like that. We all have our relationships, independent relationships, professional relationships with legislators and folks that are part of that ecosystem during that time frame, which is unusual in Nevada to other legislative systems. But I would ask that you reach out as this moves forward to me in particular, if there happens to be something where perhaps you're not getting the traction that you'd like, if it's a particular legislator or other independent lobbyist agency moving forward with an agenda one way or the other. So, please, my phone's always on for you and also for you, Vice Chair Wallen. So I would hope that you would reach out to all of us so that we can move this thing forward and get to where we need to be once this thing is over with in June.
Appreciate that. Thank you. Yeah, absolutely. Will not hesitate to reach out. I know Commissioner Lowry has her own contacts. I know Commissioner Reynolds has contacts. So yeah, if to the extent that you can be useful, as you know, we've not submitted any bills of our own this session. So it'll be more interaction to other bills that are brought up and then our budget itself. So those will be the primary issues I think we'll be addressing.
Yes, Mr. Chair, just one follow-up to that. I was glad to see that we did not propose a bill this time because it seems like every time we propose bills in whatever legislative session, they tend to take that bill and we get hammered and then we just kind of sit back and hope for a veto at the end of the day. But I think it's better not to have anything moving forward just in terms of our lobbyist of the commission in general, and being a part of that process, I think is good strategy. So I'm in favor of that as well.
Thank you. Other questions or comments? Do we have a motion to approve?
He's got the motion.
I could second that motion, Mr. Chair.
He's gonna do the motion first.
Commissioner Reynolds?
I'm happy to do that. Commissioner Reynolds, I move to delegate the authority from the commission to the chair of the commission for purposes of direction to the executive director and staff related to legislative proposals and actions during the 2025 legislative session, noting that our administrative regulations permit the vice chair to perform duties of the chair in the event the chair is unavailable or conflicted from acting on a matter. I would also indicate that that the vice chair and chair work in concert with each other on legislative matters as they may occur.
Mr. Chairman, I can definitely second that motion.
Okay, so we have a motion by Commissioner Reynolds, a second by Commissioner Moran. All in favor?
Aye.
Any opposed? Motion passes unanimously. Thank you. That brings us to item number 7, notice of granted extension to pay civil fine and ethics complaint number 23015C regarding John Bartlett. Executive Director Armstrong.
Thank you, Mr. Chair. Similar to the delegation that you just passed, this commission has previously delegated to the executive director and in certain cases, the chair, the ability to extend someone's payments. If there's a payment based on a stipulation and they're not making the payment to reevaluate that particular payment structure. If it goes beyond 6 months, then it's the chair who grants that extension or evaluates and decides whether or not to grant it. And then in our delegation, in our policy, it's just required that we notify the commission that has occurred. So this is just an information item. There's no action on this particular one. In the case of 23015C regarding John Bartlett, which was a stipulated violation of the ethics law, the counsel for Mr. Bartlett indicated that there had been some personal issues preventing the first payment in this matter as it was due in the stipulation. So the first payment will now be due no later than June 1st, 2025. But the request with the recommendation I made to the chair, which the chair approved, is that the final payment date remain the same. It's just that first date. So you don't have me coming to you talking about non-payment because you missed the first payment. So we just move that first date. That's all that particular one is.
Any questions on that matter? As the executive director noted, it doesn't require action, so we'll move on to item number 8. Is the executive director's report on the agency status and operations, possible discussion, including without limitation, budget update, regulation update, and upcoming meetings.
Thank you, Mr. Chair. Again, for the record, this is Executive Director Armstrong. I would note there's a written report in the packet of materials. We want to welcome new Commissioner Smith. We also have new Commissioner Caleb Cage, who couldn't be here today, but 2 new commissioners on the commission. In terms of operation highlights, we had our outreach and education officer Harvey and investigator Terry attend the 2024 COGL conference, which is COGL, for those who are not familiar, is like the Association of Ethics Agencies in North America. And I think they had some attendees from Africa this year as well. It was, I think traditionally it has been the executive director and commission counsel that goes to this conference. Liz and I went to our first one together and decided this is a great conference, but it shouldn't just be for the executive director and commission counsel, that there's value in sending other folks. So we're kind of on a rotation of folks going. We do, and there will be an article submitted for the Nevada Lawyer magazine in, I believe it's either March or April of this year. Their issue is going to be about government law. And so we're submitting an article celebrating our 50th anniversary and talking about the history of the commission. So that will be exciting to see come later this year. And then the legislature will start to begin. You'll get those weekly updates from me as it goes forward. I want to thank all of our staff members for working on the strategic plan. As you remember, you approved a strategic plan and we are not letting it sit on a shelf and collect dust, as sometimes happens with strategic plans. So we have an implementation plan. Sam has already started a quarterly checking process of numbers, so we can see like once a quarter, are we looking good? Are we looking not good in terms of total number of folks trained? Liz has done amazing work on creating some uniform templates for us as we make different recommendations. The reputational survey is not out to commissioners, but will go out to commissioners soon. That was the first step in that item was, what do we want the reputation of the commission to be going forward so that then we can put together an appropriate campaign to make sure that's so. Everybody is working on a time study this month, which I think everybody has reported fascinating items. I'm like, I didn't realize I spent that much time on that particular task. And so we have that. It's going to be 3 over this year, 3 months. We'll take a look at that. And then technology and service improvements. I said we were awaiting the governor's recommended budget. We are no longer awaiting that, as I'll talk about in the next item. And Curtis has been working on like a process review template he has completed to say, okay, let's look at every process. Can we improve it with technology? And so that review process will happen soon. So we're making good progress on all of that. Carrie has done great work in trying to hunt down different ways to retain and recruit folks and support current staff members as well. In terms of the budget update, the budget was released last night, scrolling through on my phone as I was prepping for today's hearing. Some additional funding is in the governor's recommended budget for us in terms of educational subscriptions and resources for our outreach and education operations, which is great. And then in addition, our requested the case management system upgrade is also included in the governor's budget. And so we will prepare to make that budget presentation and explain why the people in Nevada would benefit from upgraded computer systems. So that was one of our requests that most aligned with the governor's strategic priorities. And so we're glad to see the request in there. In terms of fiscal year 25, we have regular meetings with our fiscal folks and our projections are looking fine. We're not. There may be always those end of year work programs to move from category to category, but there's no big issues right now. And then we have some upcoming meetings. February 19th will be in Las Vegas. March will be a month where we only have panels, and then April 16th we'll be back in Reno. I do want to talk about the quarterly case log, which is new. I want to thank Carrie and Sam for getting this figured out. We're hopeful for is this new log will actually save us tons of hours at the end of the year when we go to do our data, because we'll be able to collect it. So it looks a little bit different. I would remind the commissioners that they have a confidential version of the case log, that there's a public version. So if you have a question about a case, ask by case number, not by case name, because the names are redacted out of the case log. So what should you be looking for as a commissioner when we present this case log, which we do quarterly? I think the most important thing to take a look at, so that you're aware of how we're doing in terms of keeping up on cases, is if you look at there's like columns that are white, purple, white, and there's like a multicolored section. And then there's the final white section. That first one in that final white section says pending panel, right? That's our number of cases that are currently under investigation. And what I will tell you is that 24 is what we currently have under investigation. That is a pretty high number, but it's also in some ways misleading, and I'll explain why. So we have 24 cases that are currently pending panel. Out of that, we have 8 of those, which are really one case with just multiple subjects. And that will be heard today. So that will clear those 8 cases. We have another of those 7 that are, there's multiple members of a body who are the subject of those investigations, but it's really one investigation. So when you kind of shrink that down based on all of that, after the cases we process in the review panel today, we'll be down to 10 real separate cases, which is about, I think, where we should be on any given time. So those are pretty good. You can also kind of see the numbers at the top reflect. So you can see so on this, particular one, in terms of this fiscal year, we've received, of the complaints received, 67 have been withdrawn, request, or dismissed. The other item I would point to that we haven't had before that is helpful, if you look at the top, the number on the far left, the 71, that is the number of days of process time from the time we get a complaint till it is done. So we'll continue to work on this case log. Like I said, as commissioners, I think you want to keep an eye on that pending panel number. We'll always tell you to the extent we're working on open cases, what that caseload looks like. And then you can kind of just see where we are in terms of number of cases received. I'll say as a mark that is, these are all done by fiscal year. Our case numbers are done by calendar year. And when we hit the end of calendar year 2024, we had about 23 cases more than we had in calendar year 2023, which was a pretty substantial increase again. So we continue to see increase in the number of incoming cases, which I think is good. So with that, I'm happy to answer any questions about the status of the executive director's report. or the case law.
Questions?
Mr. Warren.
On the budget, all right, so I know that last year. The legislature decided that they were gonna do a salary work classification study. What happened with that, and is that gonna have any changes to the commission
Yeah,
and the staff?
thank you.
So I didn't hear anything about it last night.
Yeah, so last night was the state of the state, and so the governor presented his priorities and the budget was released. I haven't taken a look at like the larger, budget items to see what is in there. There was a process of a reclassification study. And then that was also gonna go with a compensation study, so I don't know if that's still in progress. Again, it was not mentioned last night. I did participate in interviews with the Department of Administration about the classification of our positions and what those titles might change to. But I've received no information if there's gonna be, typically, if there's a package that is going to increase salaries across the board or do something like that, it might be a separate bill and outside of the actual proposed budget itself. So we'll keep an eye on that. On that one, we're keeping track of all the new bills as they pop in. So we'll keep an eye out for anything that looks like that.
Was there anything in our budget that you asked for that we didn't get?
We asked for an office relocation from Carson City to Reno to help with recruitment and retention. And most of our business is all done up in Reno, so that was not included. So if we want to relocate the office, we'll need to do that within the current funds. So we'll have to take a look at that. I mean, there may be a situation, where although I think I'm almost at a point where we've got a plan, long-term plan for the associate council position. But let's say we were to open up, if that falls through, that we open up the associate council position statewide, the best person is in Vegas. It may be that we get a tiny place in Las Vegas and a tiny place in Reno, and that is covered by the cost of currently our space in Carson. But the relocation costs were not approved.
Okay. The other thing I just want to say, I really love that SharePoint that we're using. I think it's a fabulous tool, and thank you for doing it. And I hope the other commissioners are finding it very easy to use, and
It's taken me a little while to get used to it, but I'm getting used
you're
to
an
it.
old dog. They can still teach you.
I will say, just to echo Chair Wallen, that the SharePoint, the executive director and Elizabeth were kind enough to come down to Las Vegas and visit with me earlier in the week and kind of go through that. And it really, it's really a great tool, and it really puts everything onto one platform. And it makes it very, very easy to navigate and to have all these materials, which there are a lot of materials available and tools available to us as commissioners. So I'm really glad to go to that. I'm glad that we are on that particular platform at this point in time. It is very, very helpful. So thanks for the time put in and the effort on that.
Yes, and I believe Executive Director Armstrong, you're the one who put this all together. Is that correct?
Yeah, I mean, I kind of played, we don't have, it's wild what the IT services we pay for do and don't do. But, with help from everybody and figuring out where there's forms and how to make it look correct and figure out how to upload things. It's been a team effort to get it up, but I'm certainly taking the lead on.
Well, I want
Figure
to
it
thank
out.
you and your staff for putting it together. I think it's a fabulous tool. Just one other thing I would, one other thing I just want to bring up. All of us as commissioners, you received a registration for
Oh,
cyber
yeah.
training. And I did my cyber training. And I think that we as commissioners, we all have an obligation to do it. Part of the cyber training, it even says it's not just certain people that have to do the cyber training, it's all of us. And I think we all have a responsibility to make sure that our state IT systems remain secure and safe. Plus, you'll learn some things that might protect you in your business and in your personal life. So I suggest you do it. It takes about an hour. And there's actually an agreement in there that you have to sign at the end. So please do your part.
Yeah, and that reminded me, Commissioner Smith, need to get you signed up for that along with Commissioner Cage. It's actually a pretty good training, the current
It
IT
is.
training, and I'll give props to the vice chair for doing the right IT thing. When she got the email about the training, she called to make sure it was legitimate before clicking all the links, so that was what we.
That's what I do.
That's what we always like to do, so thank you. Thank you.
So yeah, so those are my only comments there, and we'll see what session brings us.
Any other comments or questions from commissioners? Commissioner Lowry.
Thank you, Chair. Executive Director Armstrong, thank you so much for extending the opportunity to your team members to attend those national conferences. I wholeheartedly support that kind of leadership and sharing of those opportunities with your team. Was the time study that you engaged in, is that unique to our organization, or is that a statewide, all agencies are involved in a time study right now?
Yeah, thank you for that question, Commissioner Lowry. One of the strategic plan priorities adopted by the commission was to ensure that we have sufficient staff to carry out the mission of the commission. And so one of the implementation tasks for us is to look at what staff are doing now, so that if we want to make a future ask for staff, we can make the most appropriate ask. So it's not from like the Department of Administration, or it's part of our implementation of that strategic plan. The idea is we'll do the time study that will let us know like what activities is there enough activity for a new X person, right? Because figuring out we needed a SAM was super easy. I think that was an easy thing for us to find. I think Harry and I agree, like if we had somebody who could do IT, HR, and fiscal, right? But like somebody who does all three of those together is not really a position. So that's what it's for. It's not, it's for executing our strategic plan.
Well done. Excellent. I think that's going to be great data for us to have when we do move and ask for additional positions. You kind of addressed it. I was going to ask what the latest is on our associate counsel position, of course, because I do worry about all of you and the load that you continually carry. And I understand you can carry extra loads for a little while, but for too long, it gives me concerns for all of you. So that associate counsel position is uppermost in my mind.
Yeah, we'll hit the year mark, I think in March is when Liz was moved up into the commission counsel position. I was able to get a great contact from Commissioner Reynolds. And I spoke a little bit with the attorney for injured workers who had a creative program to get folks in. He gave me the structure. He also said that pipeline that used to be great has like dried up in the last 2 years. That Boyd isn't sending him those folks anymore. But I think I'm hopeful that by February, I'll let you know what our plan is to get that position potentially underfilled and then have that position like it's like an auto step up when the individual meets a qualification.
Okay, thank you very much.
Any other questions, comments? I don't think there's anything that requires a vote here. Correct. So let's move on to item 9, which is our report on outreach and education and possible discussion. And Sam, welcome.
Thank you,
Turn it
Chair.
over to you.
Thank you, and good morning, everyone. All right, so I'll go ahead and dive in. We'll review all of the different tenets of outreach and education, as well as PIO duties and publications as they are updated since the last time I've seen you. So starting with outreach, we are wrapping up our newly elected officers, social media training and outreach specifically for them. We had 15 in attendance to our newly elected officer briefing, and I think that was received quite well. And our last post will go out today, the kind of, oops, you missed the deadline, file your acknowledgement form quickly post to finish out that effort for the year. Next up, I emailed to all of our state of Nevada department heads to help encourage more newsletter subscriptions. So they were kind of given the option, you can either give us a list of emails for your agency, you can forward this message along when you subscribe yourself, or, something kind of in between if you have leadership you'd like to offer to subscribe. And so we've seen a handful, I'd say, between 15 and 20 new subscriptions to the newsletter, but nothing massive in that undertaking. Looking forward to some boards and commissions outreach through the governor's office in conjunction with their promotion of this bill, as I'm sure you heard about in the State of the State last night. And then we'll be developing 50th anniversary outreach for the remainder of the year. So welcome everyone into our 50th year of Ethics in Nevada. And you'll be seeing more things from us as we go through the year. I also wanted to extend my thank you to our executive director. It was a really wonderful opportunity for me to attend COGL this year. And I was really enjoyed the ability to connect with fellow ethics training staff, workshopped our different outreach partnership models to figure out what might be the best option based off of what other, other agencies and states and even folks in different countries do, as well as learning different ways that different commissions collect feedback on their trainings. Was really useful for me, so I really appreciate that. A brief update on our social media outreach is provided in the report, and we're starting to keep an eye on other social media platforms such as Blue Sky, as we're seeing a small decline in our X followers, although as of today we are back up to 350, which if you don't have the report in front of you, that's where we were in December. So we might see some fluctuation there as folks are disincentivized to use that platform. All right, so in terms of education, we've had a number of recent trainings. It's been a wonderful, busy time for us at the commission. We wrapped up the bulk of Nevada Gaming Control Board trainings in November, as well as visited with the Board of Museums and History in December. We've also trained the majority of the Clark County Las Vegas Library District staff through 3 live trainings, and then the use of Nevada Ethics Online, and also met with the Douglas County School District earlier this year. You'll see the myriad of trainings we've got coming up, keeping us busy. And as part of our strategic efforts, we're trying to do quarterly check-ins on what our training numbers look like in comparison, not just to the year prior, but trying to look at what it looks like compared to the last, let's see, 3 or so years since we've been collecting the data on the number of people trained. So we started tracking the number of people trained in January of 2023 at the direction of our new executive director, and the average number of people trained in any given 6-month period since January 2023 was about 687 people. So we've hit approximately double that in the second half of 2024, just to give us an idea. And it still was a significant increase, even if you're looking at live trainings as well. So I would say we're doing fairly well for our training goals and strategic priorities to increase the number of people receiving ethics and education resources through our training, which is exciting. All right, moving on to publications, we're continuing with the rebranding improvements of our educational resources, and we'll also be sending out the 2nd issue of our newsletter later this month. We're in the midst of developing an ethics ambassador toolkit within Nevada Ethics Online for agency representatives, and this is one of the ideas that came from the inception of Nevada Ethics Online, to have a way to train the trainer within our agencies, to empower them with the information and be able to disseminate that to the rest of the staff in their agencies. And we've modified this based off of input actually from our team, as well as some of the other fellow trainers I met with at COGL, to frame it as an ethics ambassador toolkit. And so we'll be working on that in the coming months and pitching that to department heads as well. we're also, as always, continuing our review of the manual on a regular basis to always keep an eye out for improvements and additions as we continue that project since it's been published. Finally, with regards to public records requests and requests for information, we're at a total of 60 since the start of our fiscal year, so since the beginning of July. And just as an idea, compared to where we were last year, we had about 13 public records requests by this time in fiscal year 2024, and we're at about 18 now in fiscal year 2025. You can see the distribution of that within the report, but at this point, I'll be happy to take any questions.
Thank you. Any questions or comments from commissioners for Outreach and Education Officer Harvey? Vice Chair Wallen?
I know, of course. You answered most of my questions when you're going through there, because I didn't know what NEO stood for, and so thank you. So on the X followers, I know that it's declining. Are we gonna look to go to the other platform that's not X? Because do you think that some people are leaving X now? So have we thought about, I don't know, what's the name of the other platform?
Oh, there are like 1,000 others.
But the one that,
A lot of folks have departed for an application called Blue Sky.
okay,
And I know I'll defer to Sam. I know that they had some productive conversations with folks in similar situations at Kogel about what platforms
are most effective.
are most effective.
Yeah, absolutely. It seemed like the general impression based off of other agencies in the room at Kogel was that, you know, about, I think I would say approximately a third of the folks in the room raised their hand when they were adding or replacing Blue Sky into their, you know, social media outreach and repertoire. And, you know, outreach varies greatly from jurisdiction to jurisdiction because their jurisdiction varies so greatly as well. And so I think we're going to be looking towards similar government agencies and what they are leading with in the coming months and year as, you know, the uptake on this new platform unfolds. But for the time being, we're not necessarily duplicating efforts. I think we're seeing fairly limited interactions, you know, prior to the election or prior to even September or August of this year on X to begin with. You know, most of our engagements, you know, the bulk of our followers, most folks want to hear about work stuff when they're on a work-related platform is my impression. So it's not necessarily a huge driver for us to join Blue Sky at this time, but we're hoping to, you know, continue to adapt as things change and adapt and do what's most needed to make sure we have the outreach and education information distributed to as many of our public officers and employees as possible.
And then just on our 50th anniversary celebrations and stuff, I know we were talking about it last year, I think, when we still had Vice Chair Duffrin. And one of the things that we wanted to look into is getting a commemorative coin printed up from the museum, you know, with their press and stuff. So I don't know if you thought about looking into that. I know we were looking into getting one done and 2 years ago, but the press was broken
Oh, I see.
for quite a while.
I saw a 50-year commemorative coin at Kogel for Kogel. So if we're looking for, you know, design ideas, they might have.
Yeah, so that's something to think about doing and getting in touch with the Nevada State Museum. Because I know that, you know, Vice Chair Duffer and myself said, yeah, we'll pay for coins and stuff, so that would still stand. And I think that'd just be kind of cool.
I know it's back in operation, so
Yes, it is.
we can certainly take a look.
Yeah, and then, you know, I don't know who was the governor when we started the ethics commission, but if that governor is still alive, it would be nice to, you know, if we do some commemorative event or something to celebrate the ethics commission, it might be nice to invite.
It's Governor Bryan who got it restarted.
Got it restarted.
The
Okay.
original start, I don't know, Callahan.
Yeah, I don't think he's around. So maybe if Governor Bryan got it restarted, it'd be
Restarted.
great to have Senator Bryan, you know, take part in something like that. So I think it's, you know, it's something to say that's
It's
been
in his,
50 years.
his memoirs book.
Oh,
Yes,
oh, you've already read it,
presentation on, so
okay.
it's in there.
All right,
That's why I know that
okay,
when we started.
great, so those are just, I'm just throwing out some things and stuff, and so I'm
Wonderful.
looking forward to the celebration.
Absolutely. Thank you very much, Vice Chair.
That's all I have.
All right, any other questions, comments? I think then that brings us to item number 10, which is commissioner comments. Any general comments or future agenda items you'd like to see?
Well, I just want to say, Commissioner Smith, it's a pleasure having you on the commission, and I really look forward to working with you. And I know you got kind of thrown into things, a review panel, your first time at a meeting, but thank you for your contribution. Appreciate it.
No, I really appreciate it. It's a privilege. I'm looking forward to meeting you all in person at the next meeting. And I'm enjoying the process. So, thank you. And I concur with the comments on the SharePoint as well. As the new person, it was really helpful to have, as well as the other, people calling me and just trying to help me out. So anyway, thank you all.
Thank you. Any other comments from commissioners? Anything else we need to know, Ross, before we go to the last public comment?
No, I think, just be aware of that February date. If you're a Northern Commissioner, let Carrie know as soon as possible if you think you want to travel down to that, and we'll coordinate your travel.
And that brings us then to public comment. Do we have anyone? We don't have anyone in the room here. Do we have anyone online who would like to make public comment?
We do have members of the public online, however, none have indicated they would like to make public comment at this time.
Okay. And any emails that have come in since the meeting started?
We have not received any emails providing public comment.
With that, I'd accept a motion to adjourn.
So moved.
We have a second?
Second.
All in favor? Aye.
Bye.
Any opposed? Passes unanimously. Thank you all. Looking forward to seeing you in February.
For the panel members, Commissioner Moran and Smith, let's take like a 5-minute recess, and
Yes.
you'll want to log into the panel link
I need
at
a little
12:05.
break here.
And we'll finish that last.
Waited that much longer.
Good, thank you.
How about we will take a break?